presentation and the next, you will see excerpts from a trial of a speeding case. The prosecutor represents the state. Mr. Law represents himself. During argument and testimony, objections will be made and the judge will rule on them. I will discuss these rulings as we go. The participants in this trial are the judge, the prosecutor, Mr. Law, and Officer Best. Ready?
The court calls the State of Texas versus Scott Law for the offense of speeding. Are both sides ready for opening argument?
The state is ready, Your Honor.
I guess so.
Mr. Law, would you please stand? Thank you. Sir, you will need to stand each time you address the court. Do you understand?
Yes, sir.
You may be seated.
All objections or arguments to the court should be made only by the attorneys or the defendant. They should stand and always make their objections calmly and clearly. If a judge does not control the courtroom, one side or the other will, and justice goes looking.
Ms. Prosecutor, you may make your opening remarks.
May it please the court, Mr. Law, ladies and gentlemen of the jury. Today's case involves speeding, an offense that affects us all. Mr. Law was clocked going 68 miles per hour in a 45 mile per hour zone. And Officer Best will testify to getting a radar reading, giving Mr. Law a citation, and his other observations. Pretty simple facts. But the most important fact is that you must find the defendant guilty. He is guilty. Just look.
I object. She's telling them I'm guilty and there hasn't even been any evidence presented yet. What happened to innocent until proven guilty, Ms. Prosecutor?
Sustained. Ms. Prosecutor, limit your remarks to proper opening comments. Mr. Law, you should not direct any comments to the prosecutor.
Although the opening statement or argument is clearly meant to be persuasive, it should also be limited to proper topics. Those include discussions of what the parties expect the testimony to be, as well as relevant law and general matters. Although no rule or statute addresses this issue, the basic fairness at the defendant's objection clearly merits the court's ruling. Objections must be made to the court. Don't let the parties argue with each other. Watch carefully. I'll talk with you later.
Mr. Law, do you wish to make an opening statement?
Yes, Your Honor. I was there. I wasn't speeding. The cop's a big liar. Heck, everyone in town knows...
Objection. The defendant is testifying, not proper argument.
Sustained. Mr. Law, limit your comments to what you expect the evidence to show.
I wasn't stopped because I was speeding. There was another motive here. Watch. Just watch. It's a big frame-up.
Arguments are not evidence. The parties should not state their opinions. Evidence comes in through witnesses. In order to testify, a witness must take an oath. If opening statements get out of control, the trial is likely to follow.
Ms. Prosecutor, please call your first witness.
Your Honor, the state calls Officer Best. If it please the court, we would request that the rule, that is, the exclusion of witnesses from the courtroom, be imposed. All witnesses should be sworn and given instruction not to listen to other witnesses' testimony or to discuss their testimony with anyone except the attorneys or self-represented defendant. Exclusions can be made for experts if the court finds their testimony would not be influenced by hearing other testimony. A victim can only be excluded if the party requesting that the rule be invoked establishes that the victim will also be a witness and that their testimony would be influenced. The defendants themselves cannot be excluded.
Everyone who knows him or herself to be a witness in this trial, please come forward. Ms. Prosecutor, Mr. Law, are Mrs. Law and Officer Best the only witnesses you intend to call?
Yes, Your Honor.
Yes, Your Honor.
Raise your right hands. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Yes.
Ladies and gentlemen, The rule has been invoked. The rule means witnesses who are not parties to the trial must remain outside the hearing of the courtroom at all times while testimony is being heard, except when testifying or until they are discharged. If you're a witness, you must stay close enough so that you may be reached when needed. You must not discuss this case among yourselves or allow it to be discussed in your presence, except in the presence of attorneys or under orders of the court. You must not read or watch any news reports, commentary, or correspondence on the testimony of the case while under the rule. If you will, please wait outside until you are called.
Each and every witness should be sworn in front of a jury. Under Rule 603, a witness who has not taken the oath is not competent to testify.
Officer Best, please take the stand. You may be seated.
Officer Best, please introduce yourself to the jury.
My name is Donald Best. I'm a peace officer here with the Midway Police Department. I've been an officer of the law here for the past 14 years.
Have you received any training as a peace officer?
Yes, ma'am. I spent 14 weeks in the Midway Police Academy, and in addition...
Objection. The officer's training doesn't matter.
Your Honor, we're seeking to establish his qualifications.
Overruled.
Evidence must be relevant to an issue at trial. It must be related. Since this is a traffic case, the officer's training in traffic enforcement is related, as introductory information about witnesses is generally considered relevant. When ruling on objections, always clearly state whether the objection is sustained or overruled.
Officer, you may continue your answer.
I've also completed numerous continuing education courses in law enforcement.
Starting at the beginning and continuing to the very end, describe your interaction with the defendant, Mr. Law.
Sure, on March 1st of last year, I was on the afternoon shift working radar on Farm to Market Road 5050. I saw an approaching Pontiac Firebird. I turned the laser-derived radar onto the vehicle and...
Objection. The witness is just going on. I won't even have the chance to object. Isn't the prosecutor supposed to ask questions?
Sustained.
In trials, the testimony must proceed by question and answer. This provides an opportunity for the other side to object and for the court to rule. This doesn't mean that the witnesses can't give long answers. However, witnesses should not be able to move from topic to topic and event to event without being questioned. This objection is usually referred to as narrative response. Officer Best, what did you do when the 1997 Firebird came to a halt?
Well, in 1983, one of my fellow officers was shot in the face by a driver of one of these muscle cars. He bled on the side of the road for over 20 minutes.
Objection. That's not what she asked him about.
Sustained. Officer Best, please limit your responses to the questions asked.
Should the jury be able to consider that shooting stuff?
Mr. Law, you need to make your objections statements or requests, not questions.
Why object to him talking about some killing in the early 80s? I also asked the court to tell the jury that it was not fair to have talked about that.
Objection sustained. I will instruct the jury to disregard the officer's last answer.
Remember, you don't advise the parties. You rule on objections. The testimony must be in response to the questions. The officer's answer was not a response to the question asked. So the proper objection is unresponsive. If inadmissible evidence does get in front of a jury, such as the irrelevant testimony given here, it is also permissible, on request by a party, to instruct the jury to disregard the improperly presented evidence. What did you do as you approached the Firebird?
I loosened my weapon in the holster and I checked the back seat of the vehicle on the way to the window.
Why?
I object again. Not relevant.
Sustained.
The previous story by Officer Best is now more relevant in explaining the officer's procedures. However, under Rule 403, the court must balance the relevance against any danger of unfair prejudice. There is nothing this defendant did that indicates he posed a threat, and to imply that could unfairly prejudice the jury.